Welcome everyone to this public lecture. This is actually the first lecture that the Centre for the Study of Governance in Society has been able to hold for 2 years because of all the goings on. So we have done a couple of smaller public workshops, but this is the first lecture that we've been able to host. So for those of you who don't know me, I'm Mark Pennington and I'm the director of the Centre. If you've been following some of our work, you may know that we're currently pursuing a project on the political economy of knowledge and ignorance. And one of the themes that that project is exploring is the relationship between power and various truth claims and how those claims are affected by different types of institutional setting. So I'm very pleased that we have with us today Professor Melissa Schwartzberg, who's going to be talking to us about the nature of truth claims in effect within the setting of juries. Melissa is the Professor of Politics at New York University, the Silver Professor of Politics at New York University. She's affiliated with the Classics Department and also, I think, the law school there. And she's the author of a couple of books, several books, I think, including Democracy and Legal Change with Cambridge University Press and Counting the Many, also with Cambridge University Press. Today, she's going to speak to us on what do jurors know. So please welcome Melissa Schwartzberg.
Thank you so much for that lovely introduction. I'm so glad to be with all of you in person today. The recent trial of Ghislaine Maxwell for sex trafficking and conspiracy charges brought to the attention of Americans and Britons alike the question of what jurors are allowed to know, specifically what types of experiences they might be permitted to share. During jury deliberations, Juror 50 revealed that he had been the victim of sexual abuse as a child. Yet on question 48 of his juror questionnaire, he had answered no to the question of whether he had ever been the victim of sexual harassment, sexual abuse, or sexual assault. Maxwell's attorneys insisted that if he had answered yes, he would have been excluded for cause and sought a new trial. Judge Allison Nathan ruled instead that this challenge would not have been granted and that the critical question was whether a juror has the, and this is a quote, the ability to decide the case based only on the evidence presented in court, not extraneous information and without bias, and allowed the verdict to stand. The question underlying the broader matter pertaining to Juror 50, what can jurors know, is rarely asked, in part because the answer may seem obvious. It might seem that jurors should know nothing. They should be ciphers. They should be unfamiliar with the case. They should not have been exposed to media or to social media coverage. They should not have had life experiences that would even seem to impinge on their impartiality. Yet the key role of the jury has always been to bring various forms of local knowledge into adjudication. This is basically a salutary feature of criminal and civil adjudication. It is an important dimension of what it means that litigants, especially criminal defendants, are judged by members of their own community. This is the point of the vicinage requirement, source of disagreement between the Crown and the American colonists, enshrined in the Sixth Amendment to the U.S. Constitution. It requires the jury to be drawn from those in the vicinity where the crime occurred. It is not merely that a collective body of lay people might, in aggregate, reach the same judgment, or even a better judgment than an expert judge. The jury is expected to render a judgment that is different and specifically positional. It is intended to reflect their experiences as lay members of the community. Of course, the type of knowledge jurors are asked to provide or to draw upon and what forms of knowledge they are prohibited from considering has changed significantly over time. Today, local knowledge takes many forms. It can take the form of community standards, as in trials for obscenity. It can sometimes take the form of social geography, as in cases in which the reasonableness of defensive force hinges upon the perceived danger of a specific location. Or it can take the form of situated knowledge, the conditions under which, for instance, a victim of sexual assault might initially decline to report the crime. But I want to show today that their use of local knowledge places jurors in a distinctive position vis-a-vis the state. It means that the state often depends for its ability to perform key functions upon the information ordinary citizens possess. Moreover, from the standpoint of jurors, there may be significant value in being recognized as a bearer of knowledge. It is a means to respect and social standing, particularly for those who have been previously excluded from the ability to serve. Yet the valuable knowledge that jurors possess can also make them liable to coercion and to violence. To substantiate these claims, I'm going to turn today to the history of the Anglo-American jury. Early English juries, including trial juries, were at least in part self-informing. There are many cases in which the details of the dispute were provided by the jurors themselves, and those few who were not informed often learned the facts from others, including the reputation of the accused. On the one hand, this was viewed as an important protection for the defendant. A jury drawn from a neighborhood other than the one in which the alleged crime had been committed was considered to be unfair. That is because the jury's judgments themselves were supposed to be based in part on their local knowledge. This was the value of drawing jurors from the local community. Jurors have sometimes been able to use the state or the Crown's interest in what they know to advance their political standing. But in other circumstances, their knowledge is given unwillingly, and they are pressed into service without any leverage to resist. Even when status is achieved through the jury, it may be short-lived. So the jury is an institution in which local knowledge and power intersect in a variety of ways. And it is important to consider under which conditions this connection may benefit either jurors or defendants. So in the talk, I'm going to offer 3 historical examples designed to highlight these complicated dynamics. The first is a case in which the knowledge possessed by community members did, in fact, enable them to improve their standing. Here I will talk about the informational needs of the Crown after the Black Death, and how the need to impanel lower status members of the community eventually enabled some of them to assert a set of rights to political participation. The second case is the jury of matrons, used in England and Wales until 1931. This is a case in which the knowledge possessed by community members sometimes compelled them to serve, but did not lead, at least not immediately, to an improvement in their standing. The third case is from the United States during Reconstruction, in which blacks became newly eligible to serve as jurors and voters. However, when blacks began to draw on their situated knowledge in rendering judgment, it produced white backlash, leading to disenfranchisement and jury exclusion in the 1880s and 1890s. Finally, at the end of the talk, I will turn to contemporary questions of jury knowledge and its challenges. I will argue that when we think about how to justify the jury and consider future reforms, the aims of eliciting local knowledge, while ensuring respect for those asked to provide it, ought to guide us. So I want to begin today with a watershed period in the collection of local knowledge, medieval and early modern England. The Crown's need to raise revenue has long served as an explanation for the emergence of representative institutions. From Magna Carta forward, these fiscal needs produced political concessions on the part of the Crown. This is considered to be crucial to the history of constitutionalism. Indeed, this is very nearly a platitude among economic historians. The Crown's ability to extract tax revenues was enhanced by institutions that enabled its subjects to consent or to exercise some limited control. But in fact, the Crown often lacked fine-grained knowledge as to its property holdings and other sources of revenue, and so it needed to solve the informational problem before it could solve the extractive one. Juries constituted the solution to the informational problem, beginning at least with the Domesday Book. As historians have argued, from the inquest juries that produced Domesday grew presentment juries, which presented information to officials. The first clause of the Assize of Clarendon in 1166 stipulates that juries should be constituted in every 100 to furnish information on oath to sheriffs and royal justices about robbers, murderers, thieves, and anyone who had aided and abetted them. And that another jury, drawn from the villages, ought to present those who were publicly suspected of committing a felony. There were also possessory assize juries, which would resolve property disputes, largely between lords and tenants, about the encroachment on the claims of the latter by the former. Royal justices presided in these cases, bolstering the Crown's authority to resolve these disputes. So here there's a way in which the interests of the juries in settling these pervasive and disruptive conflicts could at least sometimes be aligned with the interests of the king. The assize was a royal procedure, so fees and fines associated with it went to the royal treasury. And then there were trial juries, which over time rendered verdicts, spoke the truth, on a range of issues, not merely on issues of criminal wrongdoing with capital punishment, but the status of a person as free or unfree, the disputes over burdens placed on by lords on peasants, forms of trespass, interference with lands, goods, or persons. Broadly speaking, I'm going to emphasize three forms of information that the Crown sought. Information about revenues that the king could collect from inquests after the death of tenants-in-chief who held land directly from the king. Information about the performance of local officials, which they would have received largely through presentments, and a variety of threats to law and order and local stability, which trial juries, as well as presentment and assize juries, were able to convey. Jurors in the royal courts in the 13th century were expected to be knights or quite substantial property owners. In general, though, the standard description of those eligible to serve as jurors were free and lawful men. But the extraordinary demands for service meant that the conditions of being free and lawful were all somewhat elastic even prior to the Black Death. We'll discuss the status of women shortly. What lawful meant could vary. It generally meant independence of judgment, that is, not beholden to another, like a servant, a child, or even a monk. But one's identity as a lawful person could be affected by ill repute or the allegation that one had broken an oath. And free typically meant not a serf or a villain. But ascertaining whether one was free or unfree was not always straightforward. And royal administrators did sometimes tacitly allow unfree peasants to serve, even though there were consequences for officials were this fact discovered. So although these exclusions were imperfectly enforced, they also did not generate a systematic improvement in the standing of lesser peasants. That required the transformations, and specifically the changes in bargaining power generated by the Black Death. In analyzing court rules, medieval historians have shown that jury service was hereditary in the sense that certain families were associated with a distinction of serving. Historically, the longevity of a family in a specific area was a key criterion in juror selections. Ideal jurors were men of long-time residence, known familial and social backgrounds with excellent local reputations. They possessed the requisite knowledge to render judgments valuable to the Crown and sufficient local authority to have their verdicts respected. Such service was a strategy of the upwardly mobile peasant family in its quest for status and authority. But the population shock and the deterioration of socioeconomic conditions after the Black Death provided an opportunity for peasant families who had been well below these formal criteria to stake their claim. Political scientists and economic historians have long examined the effects of the Black Death for other elements of peasant life, notably its effect on peasant incomes and the general decline of serfdom. Most recently, Darren Acemoglu and Jim Robinson have traced the effects that the massive scarcity of labor had on the feudal order more generally, in part through changing the bargaining power of peasants. There are many examples of peasants demanding new terms, rejecting the terms on offer. What historians have not typically recognized is that this also constituted an opportunity to bargain over valuable information held locally, even though it is very nearly a commonplace among late medieval historians that juries constituted the eyes and ears of the countryside, and that by the mid-15th century, the jury system just ran on peasant participation. In response to the dramatic rise in wages and the efforts of peasants to renegotiate, Parliament under King Edward III in 1351 passed a statute of laborers seeking to fix wages at the levels before the Black Death and to prosecute those who fled from their masters. But lords sought to evade the statute through extras like grain allowances to secure sufficient workers. Moreover, jurors were required to give these statutes teeth, and they were not consistently willing to enforce them. Failures of individual jurors to appear during that period are also regularly reported in the rules, and in some instances, presentment juries may have declined to provide information. You can see this on the slide. The villas of Gramsby, Swinhope, and North Thoresby, and I apologize for my American pronunciation of these towns, were rebellious and would not come to present in front of the justices of the Lord King. So this was a strategy of resistance. In addition to resistors, the population reduction in the years following the Black Death led to a substantial decrease in the pool of those eligible to serve as jurors. To compensate, new men, whose families rarely served in the years prior to the plague, came to serve as jurors and other officials. As the great medieval historian Christine Carpenter has observed, this was a moment in which prosperous peasants, grown rich on the misfortunes of their social superiors, as well as merchants and lawyers, were able to aspire to gentility and acquire estates. But the poorer freeholders who had entered the land market in the period after the plague were excluded from vindicating their claims to title in the royal courts. And wealthier villains were not only frustrated by their formal exclusion from litigating in these courts, but also from serving on juries there, because these exclusions constituted a form of dishonor and stigma. At the same time, the need for the information provided by jurors as lay members of the community had sharply increased. There were a variety of types of information needed: the performance of local elites, sources of disturbances to the peace, information about landholding. The king's expenses were high, but by the late 14th century, the general view was that taxation had become oppressive and the king ought to live on its own resources. The imposition of poll taxes had been one of the causes of the peasants' revolt in 1381. So one solution was to try to collect all the revenues to which the crown could possibly lay claim without taxation. There were a variety of sworn inquiries by which the crown could collect information pertaining to their feudal rights and derive revenues from their lands. One important mechanism was the Inquisition's post-mortem. Initiated by the crown, IPMs were produced by sworn inquiries by local juries into the landholdings after the death of feudal tenants. In general, the main goal was to identify property held directly by tenants or what could accrue to the king by default and extract any value. Prior to the Black Death, IPM jurors were generally drawn from the higher ranks of the gentry. But afterwards, the jurors were at best the middling sort. The IPM lists offer barbers, butchers, skinners, drapers, even servants. An attraction of IPM service, like other jury service, though, was as a badge of respectability and authority that would enable a person to distinguish himself from his social inferiors. Yet the sheriffs and other conveners of juries found themselves increasingly drawing from the lower ranks of the peasantry, people with something to gain from their service because of the demands for jury service and the population shock, and in part because jury service had become perceived as an onerous and unwelcome imposition by members of the upper classes. A similar mechanism occurred with respect to criminal justice on the jail delivery circuits, which emerged in the early 14th century prior to the Black Death. It technically included a precept for the sheriff to summon panels of 24 knights and other free and lawful men, each of whom had 100 shillings of land or rents per annum, from the township where an offense had been committed. But this was nearly impossible to accomplish after the Black Death. Sheriffs were increasingly willing to fill the juries with anyone whose personal reputation had not made them obviously unlawful. And so In 1413, a statute emerged in response to the concern expressed in petitions that impoverished jurors were flooding the courts and were susceptible to bribery because they had nothing to lose. Here's the statute. The king, considering the great mischiefs which daily happen through all the realm England, by them which pass in inquests in the said cases, which be common jurors and others that have but little to live upon by such inquest, which have nothing to lose because of their false notes, that no person shall be admitted to pass in any inquest if the same person has not land or tenements of the yearly value of 40 shillings above all charges of the same. So this statute attempted to establish a threshold that had been widely breached on the ground. It effectively nullified the previous 100-shilling threshold for service outside of the county. A 40-shilling qualification would have made eligible service at least the middling among the peasants, yeomen, and husbandmen, both by expanding the pool that the crown now had at its disposal, but also enabling a shift in the power held even by lesser peasants. Now, the invocation of a 40-shilling rule probably rings a bell. This is because of the famous 1429-1430 statute conferring the franchise on all those with 40 shillings of income from freehold land, now matching the qualification for jurors. And indeed, it seems that the dynamics and the justification for this statute matched those of the earlier one. The worry that the poor had flooded the institution, but a simultaneous acknowledgement that the prior restrictive pool of electors was no longer sustainable. Whereas the election of knights of shires to come to the parliaments of the king in many counties of England have now by many great, outrageous, and excessive number of people dwelling within the same counties, of which the most part were people of small substance or no value, whereof every of them pretended a voice equivalent as to such elections to be made with a more worthy knights and esquires dwelling within the same counties, whereby manslaughters, riots, batteries, divisions among the gentlemen and other people of the county shall very likely rise and be unless convenient remedy be provided in this behalf. The knights to come to Parliament shall be chosen in every county by people dwelling and resident who shall have free land or tenement to the value of 40 shillings by the year, at least above all charges. And they which shall be chosen shall be dwelling and resident within the same counties, and such have the greatest number of them that may expend 40 shillings by year. And above, as aforesaid is said, shall be returned by the sheriffs of every county, knights of the parliament, by indentures sealed betwixt the said sheriffs and the said choosers so to be made. Okay, so here we have a crucial moment. We have the beginnings of parliamentary election according to majority rule, in response to poor peasants crowding their way in. Note that the first provision aims to eliminate men of small property or no worth, who are allegedly creating these vast disturbances during the elections. At the same time, it is also enfranchising the very, very lesser middling among this group. By the mid-15th century, a study in Nottinghamshire reveals, only a fifth of the enfranchised population were gentlemen or above. The second is the introduction of majority rule, the greatest number, into parliamentary elections, by which the gentry were to be counted on equal terms with their social inferiors, albeit with a lower bound enforced. So this is among the most significant developments in the history of what still remains an ongoing struggle for political equality. I believe it clearly emerged in the wake of the changes in bargaining power after the Black Death, and I believe this bargain was in no small part about the Crown's access to local knowledge via the jury. Just to give you a sense, here's one example of a customary tenant, likely unfree, a husbandman or farmer who availed himself of all of these new opportunities. He and his wife and daughter held a life tenure of a cottage and half a verget, approximately 15 acres, probably sufficient to just meet the 40 shilling level. He served in very many roles. He delivered the personal possessions of a hanged Bisley felon to the receiver of Bisley. He was the juror on assize. He was the juror on an IPM. He was absent from another summoned jury. He served as a juror before the justices of the peace. He declined to turn up with an entire jury panel. This was exactly the type of peasant who would have been excluded from service in royal courts before the Black Death, but suddenly became newly eligible for a range of different types of roles afterwards. So at a moment when the crown's need for information was especially acute, lesser peasants were able to access these institutions as a means of securing their own standing and holding oppressive officials to account. Via the jury, they rendered not merely judgments, although they did that as well, but conveyed or declined to convey information about their local communities. They recognized well the strategic value of information to the crown, and so they were sometimes willing to withhold it. They collectively would refuse to render verdicts. They would report all is well to people who were probing into officials who were sent to probe into their communities. And this was a mode of resistance well into the 15th century. Through the electoral process, peasants were at least formally eligible to play an equal role with the gentry in selecting representatives, who would then play a main role in the commons petitioning process, conveying their local concerns. They had managed to bargain their way into political agency. Okay, I'm going to contrast that case quickly with two other cases, just so you can see the difference in the dynamics. Access to information could give one standing as a juror, which I've argued helped open the door to other political rights. But although such knowledge might have been necessary to assert one's claim to serve as a juror, it was also insufficient. We can see this by reference to the first English cases in which women were impaneled, forming a jury of matrons. The jury of matrons was composed most frequently in which a woman was convicted of a crime and pled the belly, claimed to be pregnant so as to avoid execution. It could also be composed for civil cases, as in those in which a widow claimed to be pregnant with her husband's heir, but I'll focus on the criminal context here. Briefly, the typical question posed to the jury of matrons was whether the woman was pregnant with a child who had started to move in the womb. The phrase was quick with quick child, because at that point, per canon law, the first fetal movements indicated that the fetus had a human soul. So executing a woman who was with quick child also condemned an innocent child to death. As the legal scholar James Whitman has emphasized, the older Christian tradition took St. Matthew's injunction, judge not, lest ye be judged, very seriously. Convicting an innocent defendant was a potential mortal sin. And so jurors themselves confronted a degree of moral peril in rendering any judgment. This was exacerbated in the ordinary case of a capital crime. The most famous book on jury trial of the 17th and 18th century, Sir John Hall's The Englishman's Right, wrote, "Let the conscientious juryman tremble, let he be guilty of murder." The risk was even greater in the case of a woman, lest he be a double murderer, killing a quick child. Displacing the responsibility for judging whether the convicted woman was pregnant onto the jury of matrons would have been welcome to the judge and male jurors alike. It was justified both with respect to norms of decency and especially because of the ostensible special expertise of women with respect to questions of pregnancy. Scholars of family life in the medieval period have often commented that being married in the late Middle Ages meant constantly cycling between periods of pregnancy and lactation. And so all mothers were deemed experts on the subject. As such, when a felon pled the belly, the jury of matrons until the 19th century was often chosen from any woman who was present at the trial. Other lists of juries of matrons from the 15th century suggest that the same women in the ville or the city were used repeatedly. Sometimes people think that that indicated midwifery experience. An alternative hypothesis is that these were women who had some elevated standing in their communities, and that demonstrating they were women of substance and good reputation made them eager to serve as jurors, a bid for status akin to those sought by lesser peasants and wealthy villains. Yet, unlike their husbands, this standing itself somehow did not enable them to bargain for wider political rights. Perhaps because of the moral peril associated with judgment, and because of the absence of clear social or political benefit, matrons often did not serve willingly. Indeed, physical coercion sometimes was required to get them to serve. Judges sometimes had to lock the courtrooms to prevent women who sought to evade service from fleeing. For instance, in 1809, after the Yorkshire witch Mary Bateman was convicted and claimed pregnancy, the call to empanel a matron jury reportedly created a general consternation among the ladies, who hastened to quit the court to prevent the execution of so painful an office being imposed upon them. The presiding judge ordered the doors to be closed, and in a half an hour, 12 married women were sworn in court and charged to inquire whether the prisoner was with quick child. So here we have a case in which a political community needed information that was, at least ostensibly, primarily possessed by women. Where it was not freely provided by women, perhaps on the ground that jury service seemed to denote special standing, it was compelled. And this means that women had relatively little power to bargain. The only strategy they could, and often did adopt, was to find to a highly disproportionate degree that women were in fact quick with quick child. If it turned out to be false, the inference that the convicted felon must have lost the pregnancy was plausible enough. Yet this form of resistance, such as it was, gave them minimal leverage against the state. It did not enable them to expand their power in a meaningful way. Of course, the ostensible value of women's knowledge in this domain became obsolete. Obstetricians and gynecologists had acquired expertise in pregnancy by the 19th century. But women continued to serve on these juries of matrons into the 20th century, constituting further evidence that the situated knowledge of pregnancy that women ostensibly possessed, and which justified their empanelment, may have been a pretext, mostly masking men's interest in evading responsibility for the death of a quick child. So in England and Wales, only in 1919 did women acquire the right to sit on grand and trial juries, connected to broader enfranchisement and electoral reforms, including the 1918 Act allowing women to become MPs for the first time. Ultimately, it was some of the first female MPs who successfully secured the end to the jury of matrons in 1931, and it was linked to such MPs' efforts to abolish capital punishment more generally, beginning with an end to the death penalty for pregnant women found guilty of capital crimes. As we've seen, the value of knowledge held by jurors only sometimes enabled them to improve their standing with respect to the state. Sometimes it made them susceptible to coercion. Sometimes the claim that their knowledge was pretextual. Our third case is one in which jurors in fact possessed situated knowledge. This was of racial oppression. But this knowledge constituted a threat to powerful agents and to state efforts to maintain white domination, and it led to backlash. Here I want to turn to my home country, the United States, and the difficult process of expanding political rights, including jury service, to freedmen and blacks more generally. Prior to emancipation, the jury trial had already become a flashpoint. In 1793, the Fugitive Slave Act enabled a person who claimed he owned an alleged fugitive to seize the person and prove to a judge or magistrate that he or she was in fact a slave. The alleged fugitive himself could not contest the allegation in court. Abolitionists had attempted to allow the alleged fugitive to prove he had either been born free or emancipated, but this effort was defeated in Congress. In turn, abolitionists sought to secure jury trials at which the status of an alleged fugitive could be judged. To be sure, many abolitionists and slaveholders alike expected nullifying juries, that Northern juries would consistently find that alleged fugitives were free. So disagreements about the requirement of vicinage, again, the claim that juries should be drawn from the local community, arose. Jefferson Davis, who later became president of the Confederacy, argued that juries should be drawn from the community from which the alleged fugitives supposedly had fled. Here's a quote from Davis. "A wanderer is found in a village or a city, and a claim is made that he is a fugitive slave. Are the inhabitants of that village or city the best judges of whether he is a slave, or the inhabitants of the place whence he is said to have fled?" So here, too, we see that the jury's access to local knowledge here was being used instrumentally and even pretextually. The question of whether blacks could serve as witnesses was also tied to the issue of jury service. In many northern and southern states alike, no black person, even if free, could serve as a witness against a white person. Indeed, a reservation about extending the right to serve as a witness to blacks would be that this would give them the claim that they were qualified to serve as jurors. Once the value of their information was recognized and their capacity to provide it, there would be no grounds for prohibiting them. Advocates of integrated juries also drew on the witness-juror link. In 1870, Senator Charles Sumner introduced a bill prohibiting discrimination in jury selection, in which he argued that discrimination against blacks on the jury constituted not just a wrong to black citizens accused of crimes, but to the prospective jurors themselves. Denying to colored fellow citizens their place on the juries, you actually deny them justice. I say, therefore, from the necessity of the case, and also from the analogy of witnesses, the court should be open to the term at this moment, colored jurors. Opponents continued to use the putative ignorance of blacks as a basis for exclusion. In considering a bill to allow blacks to hold office and serve as jurors in the District of Columbia, Senator Reverdy Johnson of Maryland argued, "The question for the Senate to decide is whether we are willing to have ourselves tried by a jury of black men, for the most part just emerged from slavery, without the capacity absolutely necessary to a faithful and intelligent discharge of that duty, and that whites should not allow themselves to be subject to a judgment pronounced by 12 ignorant black men." Nonetheless, during Reconstruction, black men did serve on juries in some southern states. Blacks, including freedmen, served as both grand and petty jurors, and there is some evidence that they produced verdicts that at points departed from those created by all-white juries, those pronounced by all-white jurors. An important and careful study of jurors in Washington County, Texas during Reconstruction demonstrates that where freedmen served on juries, blacks who used force in self-defense against whites were not convicted, enabling a check on white violence. And here is where the moral knowledge of blacks, their belief in equality, and perhaps their situated experiences of white violence, the fact that they were bringing this into the court, became intolerable. Once their knowledge could take the form of meaningful power, it generated a backlash. By the 1890s, blacks were no longer impaneled, and the period known as Redemption, reasserting white supremacy, unfolded. Booker T. Washington observed that at the end of the 19th century, in the whole of Georgia and Alabama and other southern states, not a Negro juror is allowed to sit in the jury box in state courts. In January 1900, Senator Samuel McEnery of Louisiana argued that the hell-born dream of Reconstruction had been marked by horrors, including that black jurors were impaneled and no white man had an opportunity in criminal cases for a fair trial. For many white Southerners, allowing blacks to sit in judgment over whites was worse than allowing them the right to vote. And the legacy of Jim Crow for juror exclusion, notably through the use of peremptory strikes, persists to this day in the United States. Let me begin by drawing together these three disparate cases. The first two cases are those in which powerful actors sought to elicit information from the jury. In the first case, we saw that male peasants were able to use the leverage that they had to secure political rights. By contrast, women were often compelled to serve, to reveal this information, and this led to minimal improvements in their standing. They were unable to use it. So they did not want to reveal the information, but they were compelled, and they were unable to use it to bargain. In the third case, extending the right to serve on a jury temporarily enabled blacks to bring their situated knowledge to bear, on the basis of which they were able to exert the power to secure justice for defendants. Yet their exercise of this power produced a backlash on the part of whites, yielding long-term marginalization. This produces a number of questions for us today. So the first is, what types of knowledge does the contemporary jury elicit? What forms of knowledge does it seek to exclude? The second question is, who benefits from the provision of this knowledge? Who actually benefits from lay participation in adjudication? And the third question is, how can we elicit information, knowledge, that redounds to the benefit of the accused in a criminal trial without rendering jurors themselves vulnerable? So one big question is the scope of information or experiences that jurors may bring into trial. And here, the difference between the United States and the United Kingdom is striking. Broadly speaking, the United States controls jury access to potentially contaminating forms of information to a much greater extent than does the UK, through substantially greater use of sequestering and changes of venue. Specifically, though, the UK's vetting of jurors for potentially contaminating information or life experiences is much less extensive than in the United States. In the UK, you may know the main checks pertain to criminal records. Either the prosecution or the defense can challenge for cause if the juror is in fact ineligible to serve, or if a juror knows a witness or party to the proceedings. However, the use of more expansive checks is asymmetrical. In 1988, the right of the defense to challenge jurors without cause was eliminated, but the prosecution preserves the right to object without providing a reason, to stand by a juror, or to place at the back of the line potential jurors only to be used if there are insufficient jurors. It is characterized as an exceptional right, one to be used primarily in cases of national security, specifically for security and terrorism cases in which the prosecutor believes a juror holds extreme beliefs or might be subject to outside coercion that would ostensibly compromise the fairness of the verdict. The asymmetry is putatively justified in part because prosecutors can draw from intelligence files to determine in national security cases whether to ask for a standby. The United States, by contrast, relies on a much more expansive use of jury vetting, ostensibly designed to ferret out potentially contaminating information. There are initial jury questionnaires, which may ask potential jurors to reveal highly personal information. Recall that, as we saw at the very beginning of this lecture, one of those questionnaires, asking whether a potential juror had been the victim of sexual abuse, recently led to a challenge to the Ghislaine-Maxwell verdict. It is followed by voir dire. Here, the lawyers publicly seek information about potential jurors' backgrounds, uncovering characteristics or personal experiences that might be potentially contaminating. The voir dire is followed by the removal of jurors for cause, those who admit bias or might have some sort of experience from which bias could be inferred, even if they swear they can be impartial, or through the use of peremptory strikes, by which a fixed number of jurors, depending on the jurisdiction, may be removed without having to give reasons. These peremptory challenges are highly controversial in part because there is evidence that they still enable racial exclusions, despite a 35-year-old Supreme Court ruling in Batson versus Kentucky barring the use of peremptory challenges on the grounds of race, ethnicity, or sex. If a lawyer asks a potential black juror whether he's ever had a bad encounter with the police, the juror says yes. Even if he assures the court he can be impartial, he is very likely to be dismissed for cause in a criminal trial. And this means that blacks are challenged and dismissed at 2 or 3 times the rates of non-blacks. As I have argued throughout this talk, the jury is a crucial means of bringing forms of local knowledge, including the situated knowledge of people's lives, into the practice of adjudication. The question is, though, are the interests, whose interests are served by the use of this knowledge? In criminal trials, does this knowledge benefit the accused? Does it enable a defendant to ensure that he will be judged by those who are in a position to understand the broader geographic or social context in which the alleged crime occurred? Or does it benefit the prosecutor, who may be able to use her power to stack a jury in ways that are more likely to secure conviction, or who might threaten the use of such power to induce plea bargains? Will the risk that private information might be revealed, such as from Ghislaine Maxwell's Juror 50, discourage potential jurors from being willing to serve? And if so, whom does this benefit? Does it further raise the cost of jury trials, even reducing their frequency even more and shifting even more power to prosecutors and to the judiciary? Or can jury service be an opportunity for lay members of the community to convey their diverse experiences to each other and to enable this to constitute a basis for respectful treatment? I do not have answers to these questions, but I hope to have convinced you today that in considering the future of the jury, these are some of the right ones to ask. Thank you.
Wonderful. Thank you so much. Let me just pick up from exactly where you left off, which is maybe you do not have an answer to the question, but where are you going with this, right? Like, it seems that there are fundamental sort of like divergences in the epistemological theories that are driving the institutional design of these juries across time. And there is a fundamental fallacy in some respects in designing a juror that does what you suggested that juries should do at the end, which is to sort of like gather and reflect and respect local knowledges, which is of course the fact that it's 12 people in a country of 300 million, as opposed to, let's say, 500 in a country of 100 million, as of course it was the case when sort of like a broader jury participation was the case, for example, in ancient Athens. So is this like, where do you see this sort of like a clash of epistemological theories and the institutional practices that underpin them, sort of like taking you in terms of defining an answer to the question of like what we should, sort of like how we should design the future of juries?
Yeah, I am tempted by the idea that, in fact, we, as I sort of implied, that we are overly concerned with what sorts of knowledge jurors bring into the project of trial and adjudication and deliberation, that the efforts to police what people's backgrounds are end up making excessively restricted the pool of those eligible. So if you imagine that familiarity with the circumstances of a very high-profile trial might make you ineligible to serve, who is that ruling out? It's ruling out most people who are ordinary consumers of media. And so the question is, do we trust people when they say, I can be impartial in this case? It's true, I've heard things about it, but I haven't made up my mind. I've just heard what anybody has heard. And sometimes that suffices, but it very much depends on the particular courtroom. It depends on the judge, it depends on the prosecutor, it depends on the pool of people they have available. This is in the United States. And so I think just a greater comfort with the idea that people are are going to just need to focus on their capacity, their thoughts about whether or not they're able to keep an open mind as to the case, rather than to try to ferret out anything that might be potentially contaminating, is where we need to be going, at least in the United States. That's the basic thought.
So if I were to just follow up on the last point, is the argument going to be that when people talk about situated knowledge, they're actually not being, in a sense, situated enough about it, so that people could be categorized in a certain way because they've had certain experiences, but actually people within those categories may have heterogeneous views about that?
That's right. That's right. I mean, one of the great insights of the idea of intersectionality is that we are all laden in many ways, and we are all unique in terms of what our ascriptive traits, what are various features of our upbringing, what that enables us, what types of judgment we're bringing to bear. This is just an inescapable feature of all of our individual lives. And it might be that in a particular instance, you say, my experience is such that I cannot be impartial in this trial. And that should be respected. But the notion that the way in which we're going to move forward is to try to ferret out, or to say, insofar as that by virtue of being a black person who has had an encounter with the police that they perceived as being negative, would exclude somebody from being able to serve as a juror on a criminal trial, I think is misguided, and I think is not serving the interests either of the juror or probably the defendant. Who is it empowering? Well, I do think that it tends to empower prosecutors who know that if they're going to have this very difficult time, if jurors are able to convey to the defendant, look, this is what your jury is likely to look like, or if a defendant or a defendant's lawyer is likely to say, realistically, your jury is probably not going to be able to understand your range of experiences. It's going to be constructed in a particular way. That's going to encourage that defendant, including a defendant who believes himself to be innocent, to accept a plea. And that, to me, is very worrying.
Thank you. I have maybe a sort of more general question. In your work that I'm familiar with, you wrote about the distinction between discovering some kind of an objective truth by way of the jury and by way of actually creating that kind of an outcome, which is not really, it's not like a lost suitcase somewhere in the corner. Rather, as we go in that jury debate, the law, as to speak, is being created and discovered rather than applied. I wonder if you can speak a little bit about that in terms of the process where conflicting views, conflicting values, conflicting backgrounds, as Mark talked about it, come together around the jury table and try to categorize and adjudicate on the conflict that is being brought up before the court, let's say. So
you're asking kind of about the fact-finding role of a jury and the project of deliberation, and how deliberation ends up yielding a verdict in a particular case, and how what the phenomenology of that is, kind of what types of knowledge creation that is. Well, that's what I'm wondering. Broadly speaking,
creating that knowledge
rather than uncovering something that is the truth out there. I think that there are a variety of things that jurors learn. So some of it is going to be, and jurors are controlled in many different ways. Jurors are given the law, jurors are given given instructions, and these instructions are going to vary jurisdiction by jurisdiction, what they're allowed to what types of evidence they're allowed to consider, what's going to be excluded. So jurors are throughout the process, at least in the United States, going to be controlled in terms of what information they can process that's been given to them via the trial. When they are sitting together and they are deliberating, they are instructed just to consider that information. But of course, there's a process of interpreting the evidence that's been given them. And my thought is that this is where the situated knowledge comes really comes into play. So each individual juror is going to have his or their own view of which evidence is either incriminating or exculpatory. They're going to say, well, no, where there's a gap in their information, they can, of course, have testimony read back to them, but they can fill in each other's gaps. And that interpretive gap-filling sort of exercise is done collaboratively, is done on the basis of situated knowledge. There's also the experience of being with people, especially in lengthy trials, where a certain type of social knowledge is exchanged, and this may end up playing a role in the ultimate verdict, and it may not. It may just be a means of, at its best, facilitating relationships and respectful exchanges among very diverse people, so that you end up having, my best example is that I have a good friend who is a linguistics professor who was impaneled on a jury with a police officer. My friend is a stereotypically liberal NYU professor, and the police officer who she became friends with was much more conservative in his views. But the experience of this project of being together in the space and having lunch together and getting to know each other ended up yielding a friendship that endured long past their time in the jury trial. So that's another thing that the jury, at its best, can enable. It is also the case, as John Gastel and his collaborators have demonstrated, that the experience of jury service actually leads to an increase in other forms of political participation. So that's another the notion of political efficacy, and the idea of being engaged in this. It may be the idea that you feel competent. It may be that you have increased trust. What the mechanism is, I think, is still a little bit indeterminate. But insofar as people also learn that they can play a role, that is another thing that people learn through jury service.
Thank you so much for the great presentation. And I'm sorry if this thought is only half formed, but I guess I'm curious. It seems like there are kind of two dimensions to the story you're telling. So one is the scope of people who are included in the jury process itself, and the other is the scope of the jury process. So to what extent will the state tolerate or rely on juries for the execution of its functions? So I'm curious, in light of that, sort of how you think about the decline of juries in the modern era. Is there a story here that sort of the knowledge that juries provide is no longer beneficial to the state, such that there's kind of this counter pressure to minimize the role of juries in the judicial system? Or is there something else going on there in your view? And if, with that in mind, sort of, have you thought about what can maybe either incentivize the state to rely on juries more, make that knowledge more valuable to the state so that it's more likely that defendants are being judged by a jury rather than entering the plea bargains or things like that?
Yeah, I mean, I do think that that's part of that what you point out is part of the story, that it is, in a way, more beneficial to the state to rely less on juries and to encourage prosecutors in particular to be able to resolve matters without recourse to trial, that the trial ends up just serving as a backdrop, as a potential threat, rather than actually something that is generally used. And this is also the case. The criminal jury is seldom used. The civil jury is used even less. So part of the story, I think, is about the state. The other part of the story is also about competence, and that is really the case in the civil juries, that people think that these sort of complicated trials that make up much of the work of what would make up much of the work of the civil jury is beyond the reach of mere ordinary citizens and needs to be handled by experts. And I think that view is very pervasive. So that's another explanation. So the question is, what might change so as to incentivize specifically criminal juries? I do think that part of the story has to be reducing the power of prosecutors. I think that thinking about I don't think an end to the plea bargain is immediately on the horizon, but I think there have been enough concerns raised about the extensive use of plea bargains that would be perhaps the most important institutional change that would encourage a more expansive use of trials. I also think that there would need to be other sorts of more systemic changes because jury service is so very burdensome. So people want to try to opt out by any means. But I think that the whole vetting process, the costs associated with that, themselves raise the costs, and so trimming that itself would enable trials to be a little bit more expeditious.
I actually had a couple of very different questions. One was just in the story that you told about the post-Black Plague, the Black Death, development of peasants in the jury system. And, I mean, in a sense, you told the story there as a response to the greater bargaining power of those who had previously, in one way or another, been disenfranchised from political and legal life. But I wonder also whether there isn't a part of the story there that the state, as it were, wasn't interested in, as it were, restoring the balance of power between itself and locals, and that it was sort of allowing in a version of greater competition amongst the locals so as to reduce the otherwise rather greater power of those who were left. And so it was sort of more like divide and rule rather than a simple operation of market forces in the legal system.
Yes, I think that's basically, I think there's something to that. I think that the dynamics, and obviously there's a much longer version of this that involves the negotiation between the Crown and the local elites, and the jury's interest, on the one hand, in reporting bad behavior of local elites and having them be able to be sanctioned, and the Crown's interest in getting these sorts of information. But then there's another dynamic between the Crown and the local elites and competition for authority there, and that jurors and that the ordinary citizens may actually feel that they're better able to control these members of their community and keep them to heel than they would be were they dealing directly with royal authority or the people who were being sent by the Crown to monitor these powers. So I think that all of these different agents had different roles to play, and their bargaining power changed over time. So it is a much more complicated dynamic than the stripped down one I gave you today.
My second question was sort of a bit about knowing what situated knowledge that comes with jury service is actually giving one here, in the sense that it seems to me exactly in the answer that you gave to Stephen's question that the state may have two rather different sorts of interests here. One is actually sort of, as it were, that the results should enjoy legitimacy, and so that the legal system should function relatively smoothly. But the other is it might want the correct result. And it's not always clear that sort of whatever situated knowledge there is there, that it necessarily is always going to work in the same direction for both, as it were, the apparent legitimacy of the decision, but also its correctness in the sense that it draws on factually correct information about what went on. And so I wonder if you could say something about that and as to how situated knowledge works in those two ways, or how we're to judge how it's balanced between those two.
Yes. In terms of the legitimacy of verdicts, it is the case, as we saw, that the idea that somebody was going to be making use of their own personal experiences that had not been adequately sanitized ends up leading to a challenge of a very high-profile verdict, and that, in a way, is the worst outcome for almost everybody involved in the process. It's not great for the jurors, it's certainly not great for the defendant, and it's not great for the state at all. So there is certainly a reason to think that mere appeal to situated knowledge is going to be dangerous in a variety of ways. And that you're also right that if somebody is wrong about the question of whether or not they believe they can be impartial, if they get into deliberations and it turns out that in fact it was pushing them to they wanted to acquit even though the evidence was very much in favor of conviction, or vice versa, that's not great either. So I guess from the standpoint of the state, that you're right to say, of course, the state has an interest. The legitimacy of a verdict is going to hinge in part on its accuracy and its subjection and the extent to which it's likely to be overturned on appeal. It wants to reduce the probability of that happening. Nonetheless, insofar as the process, I think, is designed in a way to make it even more burdensome for jurors to bring theirselves into this process, it's not obvious to me that the state has an interest in that either. The state, presumably, since it has an interest in the effective functioning of the system as a whole, if it simply can't impanel sufficient jurors at some point, it's faced with a trade-off. It can either abolish the jury system entirely, and many countries do that, or it can try to reform it in ways that enable it to function. And I do think that one of these issues of jury control in terms of situated knowledge is where there's much more room to give in the United States than I think has been explored. The UK has done a much better job of thinking through these issues. It ends up, and not that the UK has a proliferation of jury trials either these days, but at least that's not another cause of its delay or its holdup. Yes, but I take the force of your question.
Thanks so much for the talk. I wanted to ask a question about the Reconstruction example. And when you put up that example, I guess the question that I had was whether or not this is actually an issue of knowledge or whether it's just one of power. And I think this might get to some of maybe the sort of the epistemic questions that a couple of people have touched on. But it's not as though the jury was being used to aggregate factual data that otherwise wouldn't be held by racially diverse juries. And I suspect that when the Republicans implemented multiracial juries, it's not because they had informational concerns. This was just a power move. And similarly, when blacks were no longer able to serve on juries, information was just not an issue. The issue was power. And I guess I'm just wondering how you'd respond to somebody that was saying this is actually not really about knowledge, or what is the kind of knowledge that this is really about, and how can we make this distinct from just issues of power? Yeah.
I think that the issue is that we often think about knowledge in too restrictive a way. And so in the first instance, when we're talking about these self-informing juries, that is literally bringing information that is trial relevant into the process of adjudication. Presumably we don't want to rely on self-informing juries, so that's clear. Then we have these broader questions of what actually constitutes the type of knowledge that people have that they might bring into trial. And some of these things are going to be their experience of a particular area in which a crime took place. So there was a famous case in New York City of Amadou Diallo, and whether the use of force against him, and whether or not it was legitimate to think that Amadou Diallo was posing a threat. And with a change of venue from New York City, from the Bronx to Albany County, it meant that Albany County jurors had no knowledge of the relative safety of this particular part of the Bronx, and they were willing to impute this great level of danger on the basis of a place that they were unfamiliar with. So one form of knowledge is going to be this sort of geographic, social-based knowledge. That is something that I think might have been able to be brought by freed blacks by freedmen and other blacks into trial. The idea, because in some of it is going to be aggregating the information and the evidence that's presented at trial, but some of it is going to be this interpretive work and saying, well, under what circumstances might it have been right for somebody to defend themselves, when might not it have been, that's going to be that sort of broader knowledge of the social geographic knowledge that we're thinking about. The other possibility is whether what might be construed as power is also a form of moral knowledge. So if you're bringing into trial or into deliberations your belief in white supremacy, or if you're bringing into trial your beliefs in the equality among the races, that's also going to color the way in which you're sifting through evidence. So my thought is that by impaneling Southern Blacks, there's a whole range of experiences that they're going to be able to draw upon in assessing evidence that is going to be different from white jurors. This is not to say that the reasons for an inclusive jury are not essentially about power, but it is to say that the way in which power operates in this context is through the exercise of knowledge that happens through deliberation and through rendering a verdict. That there's no way to read the knowledge out of that part of the project.
Any more questions? I don't think we've got any more questions. In which case, I think we should all say thank you to Melissa for a really fascinating talk and also great Q&A as well. Thank you very much.